Okay, so you may have heard that the TikTok prankster chap has now admitted to breaching a community protection notice. That's what, just a rebranded ASBO. So presumably they'd actually had words with him before and warned him about doing these things. But anyway, he's admitted that breach and he's been fined £200 plus £8 victim surcharge and some costs. Is there, though, anything else that could have been done? Well, yes, because they've also put further restrictions on him in the same terms as the previous community protection notice, but he now can no longer upload any videos without the consent of all involved, which, you know, puts an end to his sort of, you know, prankster career unless he just gets his friends to fake them, as has actually happened in a few of these cases. But were there other options available to the court? Well, not on this particular offence. However, were somebody, and I'm not speaking about any specific person here, this is more hypothetical, were anybody to be convicted of, say, like, you know, a harassment offence, although that might be difficult because harassment has to be a course of conduct, and usually in these cases, you know, there's one course of victim each time, a separate person. But there could be assault, there could be certain public order offences, causing alarm, harassment or distress. I mean, assault is just putting somebody in apprehension of the use of physical force, so that's a relatively low standard to achieve. So what if somebody's convicted of that? Well, we have something called deprivation orders. And what that is the court can seize any items that were used in the commission of offences, not even the offences you were convicted of, actually. So say, for instance, you transport some stolen goods in a lorry, they can seize the lorry. You know, if you're using tools to break into places, they can seize the tools. What could they do here? Well, they could probably sort of take anything that it was filmed on, they could seize the phones, but here's an interesting thing, and you know, this is an art stroke media law subject. We talk a lot about intellectual property. Are your social media channels property such that they can be subject to a deprivation order? In other words, can the court say, right, hand over all your passwords and account names, those social media channels are now ours? That's an interesting one because property isn't defined. In deprivation orders, the only thing they're clear of is you can't seize what we call real property. That's like land and houses and things. But yeah, I mean, intellectual property is a species of property. So, you know, is that a route the courts could go down? Because that would be one way of just, you know, stopping people doing this. There's also something called proceeds of crime. Under the Proceeds of Crime Act, anything you receive as income from crime, although it doesn't just have to be cash, it's anything you gain from committing a crime, that can be seized. And also, it's not profit, it's not confiscation in the sense that a schoolboy would understand it, as the authorities say. It's basically, it's turnover. It's anything that's come through your hands. So it doesn't matter, you know, that's gross. So even if you've got expenditure, even if you're left out of pocket, they still say, right, you've had X amount of money through these accounts. We don't care what you spent it on. You now owe us that amount of money. So anyway, they're just a few options that I just thought might be worth considering. And if this phenomenon continues, and it seems, you know, fairly worldwide, who knows?